Hi, this is Attorney Frank Malatesta, and today I wanted to talk a little bit about the EEOC process. So, you feel you're being discriminated against. How do you go about protecting yourself from retaliation or filing a claim and starting the process? Now, every single claim that's related to Title VII, which is the Civil Rights Act, which is primarily responsible for most of the discrimination um, that takes place in the workplace. So that's where you have to go to seek restitution or protection for violation of your civil rights in the employment realm. So we have race discrimination, we have age discrimination. Age discrimination is actually under the Older Americans Act, which means that it's a separate and distinct act than Title VII of the Civil Rights Act. Now, there are Florida components, but what Florida does, it primarily, with a few exceptions, just incorporates in exactly what the federal law is. So whatever that federal law is going to be what the Florida law is. So you can apply with the Florida Commission on Human Relations, and whenever you file with the EEOC, what they're going to do is dual file. So on your Form 5, which we'll get into in a little bit, you're going to go ahead and you're going to see that it was also dual filed with the Florida Commission on Human Relations. Now, if you are going through this EEOC process, step one is you have to let them know. So what are the different ways you can let them know? So EEOC.gov, that's a great website. It's going to provide you with all that information. It's going to provide examples of what discrimination is, what types of discrimination, everything from sexual harassment to age discrimination to the American with Disabilities Act. All of that goes through the EEOC clearinghouse. Now, the EEOC gets thousands upon thousands of inquiries in a given year, which means that they investigate, but they're not necessarily going to prosecute your claim for you. They only take a small percentage of the number of claims that come through the door. So you have to have some kind of special circumstance. It has to be kind of a media-friendly area of the law, whatever that might look like. Or it might have to be with one of their groups that they're trying to concentrate on better protecting. For example, one of the kind of sexy issues might be that the EEOC might try and go after people who are taking advantage of immigrants, migrant workers. If they felt that they were being discriminated against for whatever reason, maybe that was something they wanted to get out because whoever was in charge of the EEOC through the White House, etc., decided that's where they wanted to focus. Unfortunately, it is kind of political. So someone who's involved in maybe race discrimination, if you saw that in the newspaper, would you blink? No, you probably wouldn't blink, unfortunately. Maybe today, because we've got this kind of social justice, Black Lives Matter issues going on, but it's not something that's a priority for the EEOC. So you're going to make this, you're going to file with the EEOC, and how do you do that? There's a couple ways. You can show up without an attorney, and they'll have you fill out a questionnaire, and that will mark your time. You can download a questionnaire off the internet, and you can fill that out and sign it and mark one of the boxes saying you're either just interested in information or you're ready to start the process. I would recommend you mark that you're ready to start the process unless you're very, very concerned about your employer learning about it. So if you're still employed and you just want to talk to somebody, I would mark item number 2. You can still get protection from retaliation provided your employer somehow got knowledge that you went to the EEOC, even if it was through the rumor mill or they thought you might have gone to the EEOC. But it will allow you not to kind of create this complaint. It'll just be kind of learning more information. So after you fill out that questionnaire, you have met your statute of limitations effectively. Now that doesn't mean that it's not over, because there's a lot more complexity that's going to be involved in this. One of the greatest frustrations I have when representing people who are going through the EEOC process is that the next step doesn't get done properly. And after you initiate that claim, either by showing up, we've got one in Miami, we've got one in Tampa, I think there's one in Orlando, I know there's got to be one up probably towards Tallahassee, and there might be a couple other EEOC offices. But I can tell you definitely that most of my clients are going to be in the Tampa office, or they're going to be in the Miami office. But I digress. So you can go to one of those offices and you can initiate this process with the questionnaire. Now that questionnaire is not legally binding in any way, shape, or form. So if you provide information on that questionnaire that for whatever reason the investigator doesn't transcribe onto the next step, which is the Form 5, which is probably the most important document to any EEOC litigation. What you put on that Form 5 is going to control what the litigation eventually is going to be in regards to. And one of the things, please remember this, even if you're not going to be my client, because it's a pet peeve of mine. I can't tell you how many times I've seen these, we get into litigation and the complaint gets dismissed for one of the counts, whether it's retaliation or something that happened a couple months after you filed with the EEOC, that you didn't update the EEOC charge. So that questionnaire does not save you. It doesn't have, in the 11th Circuit, it's not going to be a part of your litigation. This Form 5 is a special document, and I'm going to put a link to it at the bottom of the page here. The Form 5 is a special document that is going to specifically and succinctly lay out each of the claims you have against your employer. And including that, you need a very specific articulation of the facts and circumstances that made you believe you had a complaint or charge of discrimination against your employer. So let's say you are dealing with your employer and on Thursday you are called old or black, if that's a specific circumstance that you're dealing with. Let's say they said all sorts of racially charged things, they pushed you, they spit on you for whatever reason, and they vocalized derogatory and demeaning things about your specific class, and then they kept bullying you for a period of time. So let's say you file with the EEOC and you go ahead and do that. And this person happens to be the friend of the owner. And 5 months down the road, the EEOC decides to go ahead and, or not the EEOC, but your employer decides to terminate you. If you created a Form 5 a month before you were terminated, and you don't sign an edited copy of that Form 5 or redo your EEOC charge completely, you will not be able to sue for retaliation. Let me say that one more time. You will not be able to sue for retaliation. So if you make $100,000 a year and you've lost this job now because you went to the EEOC and you don't put pen to paper and sign and hand in an amended copy of your Form 5 charge of discrimination that includes retaliation with the check mark and a brief explanation of how everything went down, you will have a great claim for the pain and suffering and other damages arising from the drama you had to deal with at work. But the fact that you just lost a $100,000 a year job and for the next 3 years might only make $50K, you've got probably a $5,000 to $25,000 case. So you've suffered $150,000 in damages, but because you didn't go and you didn't fill out that form properly, you have left effectively $125,000 on the table. So this is a great example of how not to fill out the EEOC process. So again, if you go to an attorney, he's not going to ask for any money up front to assist you with this process, or she, but you will probably end up paying a percentage. If that's a third, if that's 25%, if it's 45%, whatever that might be. It depends on the specific attorney, but you know you're going to get the amount that's going to be best suited for you. So you're not going to be leaving anything on the table. So just make for absolute certainty that you're putting everything on there properly, and I highly recommend you get an attorney to walk you through the process. Now, an attorney is not going to help make the process any quicker, because once you fill out that Form 5, you have specific responsibilities in regards to how you're going to, in how the claim is going to be investigated. And essentially, you just need to respond when the respondent kind of makes their position statement or response to the charges. So you make a charge, respondent responds, and then you're going to make a response. And this seems like, okay, that might take a few weeks. We can move. No. It could be 6 months, it could be a year, it could be 18 months. I've seen things that are 2 years to get out of the EEOC process. And during this entire time, well, after a year, if you decide, you can bring this straight to federal or Florida court, depending on where you want to end up going. I prefer to take most of my cases to federal court. The reason being is it's a little more structured and universal. There's less in-person hearings. I just find it better for my clients. I think it's taken more seriously by the defendant. So that's where I prefer to put my clients. Now, sometimes if there might have been a local ordinance or something above and beyond at the state or local level, we would incorporate that. Or if it was something that the EEOC didn't protect. So, for example, there's a lot of questions out there, and this could be a whole nother video, but there's a lot of questions out there, specifically when it comes to transgenders and sex discrimination in relation to those issues, which are kind of at the forefront. So the EEOC, the law isn't perfectly clear on how they're protected. So, for example, if your employer refuses, if let's say you are someone who is going through that process and you're treated differently, you would want to make sure that we did that at the local level. If the county provided specific protection, and those statute of limitations are different. So you have 300 days with the EEOC, you have 180 days with some counties, or you might even only have 90 days with some counties. So you want to look at the specific laws and ordinance that would be over that issue. So it all depends on what the specific type of discrimination we're facing. So again, just kind of to recap, you have 300 days to file with the EEOC. There may be county or state level nuances that would make you want to make sure that you file with Florida as well. But typically speaking, we're going to go to the EEOC. We're going to be in the EEOC from anywhere from 8 to 18 months, the typical case. And then we're going to go to litigation. Now, unless the EEOC decides to start conducting depositions and discovery, which they do occasionally, they'll make an on-site visit with the investigator. But unless the EEOC does that, you're probably not going to get witnesses that remember any of the facts and circumstances of your charges. So we're going to be 2 or 3 years down the road when we start actually interviewing people and we start working on this. It might be quicker, depending on how aggressive your investigator is to get off their desk, and it's not their fault. They're dealing with with hundreds of these, and they have huge case files. We just have to be patient with them. So there's nothing you can get by being rude to your EEOC investigator, because he or she is going to help you through this process. And that's it for this video, and everybody have a great day.